Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. You know, when we talk about custody, we're discussing where a child primarily is going to live. Where is that child going to sleep? And the court doesn't make decisions about that willy-nilly. The court takes very, very specific testimony and engages in very specific analysis to determine whether or not the custody is appropriate with mom or with dad, whether a change might be appropriate from mom to dad or vice versa. So when we talk about the custody hearings, what goes on, you got to understand that all those hearings are geared toward making that analysis about what's in the best interest of the child. Now, if there's an established custodial environment already and somebody filed a motion to change it, what can you expect at that first custody hearing? I'll tell you. The court has to do essentially a two-step analysis. Step number one is there a reason to change custody? That is to say, is there a reason, a significant change in circumstances that should cause the court to even consider revisiting the custody order? That's step number one. If the court finds that there is some change in circumstances and a compelling reason to consider it, then the court will do step two, have a hearing to determine is the proposed change in the best interest of the child. But in that first custody hearing, what you're going to expect is argument and proofs regarding whether or not there's even a reason to revisit it. And it can't be that, someone's having buyer's remorse. And it can't be that, we gave custody to mom and now the mom and the child aren't getting along. That is not going to cut it. It's going to have to be some significant reason, something that the parties could not have anticipated, a compelling change in circumstances which causes the court to say, you know what? I know what we ordered before. This is something that we didn't consider. This is something way out of the box, and now we have to revisit the custody issue. The fact that the child is having adjustment problems, not getting along with one parent or getting along better with one parent than another, that is not going to cut it because that's contemplated in the original order. The court gives an order. The court realizes it's a big change. There's going to be an adjustment. There may be ill will. There may be problems dealing with an oppositional child. That's not a reason to change it, though. That's what the court anticipates. That's the learning curve with the new environment. It's got to be something else. It's got to be something that's a significant change in circumstances to cause the court to even consider custody, and that is what you can expect to have discussed and proofs presented on that issue at that first custody hearing. If you have any questions about your case, reach out. We'll be glad to help you out.